Association of the Bar of the City of New York. I'm delighted to welcome you tonight to what should be an extraordinarily interesting and hopefully a bit of a provocative program, Lincoln and National Security. It's particularly fitting that this program happened at this association because William Evarts, who's in Evarts room just down the hall, was a founder of the association. He actually was opposed to Lincoln's nomination in Chicago in 1860 because he supported Seward, a fellow New York lawyer who he thought would be a better candidate. It was amusing that subsequently in the fusion government, Seward became the Secretary of State and the source of many of the aggressive activities that we'll be discussing tonight. We were fortunate to have two partners to tonight's program. First, we have the Committee on Legal History of the Association of the Bar, and our moderator, Dick Mcdermott, is the very able and energetic chair of that committee. In addition, we have the Gilder Lehrman Institute, who we've been blessed with doing a number of programs with over the year that have really been programs we have really been proud of. I particularly would like to welcome Leslie Herman and Susan Saberberg of the Institute, and I want to particularly thank Dick Gilder and Lou Lehrman for all their support on education and for the activities at the association. I think you've all been given this wonderful memento that they also produced, these two groups for tonight, which summarizes some of the interesting things about Lincoln as a lawyer. We now will hear from Professor James Baster of Barnard College and Columbia University. He says he spends half his time there and 3/4 to 2/3 of his time as the president of the Institute. So I'm not sure how much time to be here tonight, but Jim, a few words from you.
If any of you ever have the chance to work for Dick Gilder, who I think he's on his way from the airport after a few days in Russia on business. He's coming straight from the airport to join us. But if any of you have had the chance to work for him, you'll understand what it means to work half-time at one job and 3/4 of the time for another. And he still might call you on Sunday. I just want to extend greetings and welcome to everyone here on behalf of the Gilder Lehrman Institute of American History. As many or most of you know, our mission is to promote the study and the love of American history. We work to achieve that end in many different ways, working with history high schools here in New York City and increasingly now around the country. We produce a certain number of publications. We sponsor scholarly fellowships for people working in American history at 4 different historical archives in New York City. We are involved in sponsoring the Lincoln Prize along with Gettysburg College, which is the $50,000 prize for the best book on Lincoln in the Civil War era. We also sponsor through the Gilder Lehrman Center at Yale the Frederick Douglass Prize, which is for the best book on slavery and abolition each year. And we do a host of other things. One of the great joys for us is to partner with organizations like the Association of the Bar here in New York City. And in fact, this is our 3rd collaboration with the Bar, going back to April 1998, when we co-sponsored a forum on Amistad, Slavery, Justice, and Memory. And in May 2000, a 2nd symposium here in this room, Federalism on Trial, and now, of course, today, this Lincoln and National Security Program. For each of them, we have produced the kind of publication I hope that all of you are holding. And if you haven't got one, this is a keepsake entitled Lincoln the Lawyer. I would like to encourage you all to be sure to pick one up on your way out. In each case, we've produced a keepsake like this that draws on original, unpublished material from the Gilder Lehrman collection. In this instance, these are 3 letters of Abraham Lincoln's from the 1840s and 50s, from the period when he was working as a lawyer, and they involve reflections on his legal practice. We're particularly grateful that for this keepsake today, Professor Mark Neely, who's here, of course, as a speaker in the program, worked with, I must say, extraordinary rapidity and extreme grace to do the introduction, which I think is an elegant piece, and I hope you all enjoy it. Finally, I'd like to encourage those of you who are interested in American history to stay in touch with us, whether it's an interest in our programs, our publications, or even our website. So if you get in touch with us, drop us a card, phone call, we will be sure that you're kept on a mailing list about all of our activities. And before I sit down, I'd also like to extend a particular thanks to Barbara Opatowski for what she's done in organizing this meeting, and especially to the next speaker, Dick Mcdermott, who is the chair of the Legal History Committee here, and has been really a wonderful man to work with in pulling this all together. I hope you enjoy the program. Here's Dick to tell you more about it.
Thanks very much, Jim. Ladies and gentlemen, I'm glad to see you here this evening to discuss one of the more interesting and timely historical issues of our current era. It is one of the paradoxes of American history that the president most closely associated with civil liberties, the great emancipator, Abraham Lincoln, is also most associated with the subversion of civil liberties at the time of the Civil War. Lincoln, of course, spent 2.5 decades as a practicing lawyer in Illinois before he was elected president. He also was a politician and a political thinker who was knowledgeable about the Constitution, the Bill of Rights, and the Declaration of Independence. He was certainly sensitive to individual rights. He repeatedly represented defendants in criminal prosecutions. And he was a serious ethical thinker. Having represented defendants in criminal prosecutions, that's one thing. He represented a nation at a time of deep soul-searching about some of the great moral issues of the time. How then did a lawyer and politician with this background become a leader described by contemporaries and even respected historians, current historians, as undermining basic American liberties, as being a tyrant and a despot? And what does Lincoln's conduct during the Civil War tell us about the challenges that have faced our own leaders in our present time since September of last year? To quote Professor Stephen Newman in an article in a February 11th New York Law Journal, I quote, "If even Abraham Lincoln yielded to the pressure to excessively curtail civil liberties, what can we expect of President Bush and Attorney General John Ashcroft?" Professor Newman goes on to say in that article, summing things up, and again I quote, "If we heed the lessons of the past, we will grant them, our leaders today, less power than they demand." Now those words, the lessons of the past, provide a context for tonight's symposium. We are fortunate to have with us 3 exceptionally knowledgeable scholars on the subject of Abraham Lincoln. They will address the relationship, if there is one, between his background as a lawyer and his administration's response to the internal security issues during the Civil War. One question they will consider is whether on these issues there are any lessons of the past. Before introducing our speakers, perhaps I should clarify 2 matters of terminology. First, we will hear the expression suspension of habeas corpus. Now, I realize there are many lawyers in this room, but it is fair to say that even among lawyers, some of these terms aren't necessarily completely familiar, particularly if much of your day is spent working with trust indentions. The writ of habeas corpus is literally that you have the body, Latin for that you have the body, and it's a court order requiring a public official responsible for the imprisonment of an individual to bring that individual before the court, where the court will examine the legality of the imprisonment. As a practical matter, when habeas corpus is granted, it usually means that the matter has been examined and the prisoner is going to be released. This is an exceptionally important guarantee of individual liberty, with its origins in English law. Some would trace it back to Magna Carta. I think that's a bit of a stretch. There is no question that Chief Justice Hughes refused to allow a group of people to be restrained and imprisoned in 1482 in the decision in the yearbooks. And that actually seems to be the first time that habeas corpus was actually employed in English law, specifically to release prisoners. The concept had existed for other purposes before that. The real source of the writ, however, as we now understand it, is the Habeas Corpus Act of 1679 in England, in the reign of Charles II. And from there it found its way into our own Constitution in Article 1, Section 9, second paragraph. And that states that habeas corpus, quote, shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. So there it is in our Constitution. Very important, but not so important that it can't be suspended under specified circumstances. On April 27, 1861, only 6 weeks after his inauguration, President Lincoln suspended habeas corpus. He did so along the military line between Philadelphia and the District of Columbia. In May 1861, he suspended habeas corpus in Florida. By August 8, 1862, the administration had suspended the writ nationwide, and such suspensions continued in various circumstances and localities throughout the rest of the Civil War. That's habeas corpus. The second term I'd like to at least refer to and clarify a little bit is the notion of a military commission. Here we are talking about the use of a tribunal made up of military officers to try civilians for acts punishable by criminal penalty, including imprisonment and death. Now, the Sixth Amendment in the U.S. Bill of Rights assures trial by an impartial jury in all criminal prosecutions. The idea that this process could be taken over by military officials, perhaps the same agency, same military people who made the arrest in the first place and issued the charges in the first place, is nowhere provided for in our Constitution. Well, it happened during the Civil War. It did so, it happened with the approval of a lawyer who in another life had represented more than one civilian before a jury. That fact is disquieting because that lawyer was Abraham Lincoln. So we have a paradox, and to address the paradox, we are honored to have present three uniquely qualified scholars: Colin Davis, Stacy Mcdermott, and Mark Neely. I'm going to introduce each of them before each one speaks. I'll start with our first speaker, Professor Davis. He's a native of Lincoln Country, Central Illinois, and he's Professor Emeritus of History at the University of Illinois. From 1988 to 2000, he was also Director and Senior Editor of the Lincoln Legal Papers. Professor Davis is author or editor of many books and articles on American political history, oral history, legal history, and Illinois history, including Bench and Bar on the Illinois frontier, and the public and private Lincoln, and many others. He holds honorary degrees from Knox College and Lincoln College, and he's been a Fulbright Research Fellowship. The list goes on and on with his accomplishments. I'm going to stop now. He'll be speaking on Lincoln, the Prairie Lawyer, prelude to the present. And he'll be discussing the elements of his background, Lincoln's background, that shed light on Lincoln's approach to civil liberties during the Civil War. I'm very pleased to present Professor Davis.
congratulations for this symposium to the Association of the Bar of the City of New York and the Gilder Lehrman Institute of American History. Of our 42 United States presidents, 25, or 60%, also were lawyers who practiced prior to, and in a few cases, following their terms in office. The extent and the nature of each lawyer president's bar experience has varied greatly. Some, like James Monroe and Woodrow Wilson, scarcely practiced at all, while others, like John Adams and Abraham Lincoln, had extensive professional careers. It is the connection between Lincoln's legal and his presidential years that focuses our attention this evening. In particular, we are investigating the relationship, if any, between what he learned as an attorney in Illinois and what he did during 4 years as President and Commander-in-Chief. A brief summary of Abraham Lincoln's legal career is the place to begin. Despite the absence of any formal training or law office apprenticeship, Lincoln managed to fashion a richly diverse and lucrative general practice of nearly 5,000 cases. Except for brief interludes of political and legislative activity, he was a full-time practicing attorney for 24 years, even attending court in July of 1860, following his nomination for the presidency. Lincoln's forte was in litigation rather than the preparation of deeds and wills. And this trial work took him on lengthy, semi-annual excursions around the state's 8th Judicial Circuit, to the Illinois Supreme Court on over 300 appellate cases, and before the U.S. District and Circuit Courts in Springfield and in Chicago, and even before the United States Supreme Court in Washington. As to his caseload, we now know that common law and equity comprised the substantial bulk of Lincoln's practice, and that criminal cases, including several memorable murder trials, were relatively few. Most of his work dealt with mundane and often routine matters of personal debt, contracts, and title to real property. But there also was great variety in his caseload. Admiralty and patent work, corporate liability, medical malpractice, slander, fornication, larceny, drunkenness, reapportionment, taxation, child custody, and divorce, among others. This veritable smorgasbord of litigation gave breadth and variety to his legal experience. His active and successful career manifestly awarded Lincoln a handsome upper-middle class income, extensive writing and oratorical experience, a generous infusion of personal self-confidence, real-world exposure to most of the pressing public issues of his day, growing civic and public stature, and a valuable network of political contacts and alliances. Biographers are irresistibly tempted to find hints or echoes of Abraham Lincoln's personal and his political beliefs in the clients and the positions that he represented in court. It therefore puzzles them to confront his defense of a slave owner in the famous Matson case, or his defense of notorious criminals on occasion. That subjective notion, the notion of linking Lincoln's personal beliefs and his political clientele, is a slippery slope at best and a fallacy at worst. Contrary to popular legend and some wishful thinking, he did not apply a moral or ideological litmus test in accepting clients and their causes. A second warning pertains to our central interest this evening: President Lincoln's resort to arbitrary arrests and military tribunals. No cases among the thousands he handled as a lawyer dealt even marginally with the constitutional parameters of wartime executive authority versus individual freedom. True, habeas corpus issues surfaced in 8 of his some 5,000 cases, but their details and circumstances bore no hint of a relationship to the crisis he later faced in the White House. With those two limitations in mind, we now can turn to the problematic challenge of bridging the prairie lawyer's professional experience and his public life, including the presidency. It is virtually axiomatic that Lincoln's principal occupation for most of his adult life must surely have shaped or at least influenced his political behavior. Common sense tells us this. In the time remaining, I will explore the question by discussing first Lincoln's public discourse, his writing, speaking, and debate, and then turn to his manner of thought, analysis, and decision-making. One student of 19th century rhetoric has observed that in his public addresses, Lincoln spoke with the voice of a circuit-riding lawyer. Among the characteristics common to both Lincoln's courtroom and his stump speaking were one, an economy and simplicity of language, two, an intuitive gift for seeing an issue through his adversary's eyes and then structuring his counter-argument accordingly, three, the use of homespun stories, metaphors, and anecdotes to make a point, and four, a facility with syntactical devices like balance, antithesis, and anaphora, which is the deliberate repetition of words and phrases for a maximum effect. To readily, if oversimply, gauge how constant legal practice honed these particular skills, one can compare Lincoln's address to the Young Men's Lyceum, delivered at the beginning of his legal career, with the House Divided speech 20 years later and at his professional zenith. The former, for all of its emotional power, was florid and melodramatic, the product of a young, undisciplined mind. The latter was direct, spare, and logically compelling, the work of a seasoned orator. However, not all of what Lincoln learned about language and argument on the circuit served him well in the public arena. Consider in particular his performance in the famous senatorial debates with Stephen A. Douglas. The first debate at Ottawa, Illinois, offers the most vivid evidence. After his opponent opened with sweeping charges of an abolitionist conspiracy, Lincoln rebutted weakly. That is Weakly, devoting much time to a close textual analysis of the pertinent laws and writings. In this manner, he rather mimicked the style of an appellate attorney, not a platform debater, and with unfortunate consequences. Even more counterproductive at Ottawa was Lincoln's reliance upon esoteric courtroom language and analogies. In repeating a charge that he had first made in June, that Democrats like Douglas were conspiring to nationalize slavery, he made this highly technical argument, quote, I called Douglas's attention to the fact that he had acknowledged that he had carefully read my previous speech and still had put in no plea or answer. I took a default on him. I insisted that I had a right then to renew the charge of conspiracy. Then 10 days later, he comes in with his plea to this charge for the first time. I demur to that plea. I waive all objections that it was not filed till after default was taken, and demur it upon the merits. I am disposed to take his denial as being like an answer in chancery, that he neither had any knowledge, information, or belief in the existence of such a conspiracy. And now I ask, have not I a right to prove it on him, and to offer the evidence of more than two witnesses by whom to prove it? End quote. Resorting to the complex rules and arcane language of equity pleading to make a political charge before a lay audience of thousands was, in my opinion, an act of stunningly poor judgment on Lincoln's part. It is indeed curious that a speaker justly known for demystifying the law in the relative formality of a courtroom setting would get legalistic in a public debate. Fortunately, Lincoln generally refrained from tedious legalisms in the remaining debates, suggesting that he learned a lesson from the flop at Ottawa. John Frank, author of Lincoln as a Lawyer, has identified other public statements in which Lincoln leaned heavily upon the language and the structure of courtroom discourse. Both in his famous spot resolutions in Congress and subsequent congressional remarks, he attacked President James Polk's rationale for the war with Mexico with a series of interrogatories, more suitable in legal than in political argument. Another of Frank's examples is Lincoln's fateful speech at Cooper Institute. Now we think of it as Cooper Union, only some 30 or so blocks south or downtown of our meeting tonight. At Cooper Institute address in February of 1860. This well-received speech demonstrated a maturic forensic style rather than a lawyer's over-reliance upon technicalities. But in its structure and its mode of expression, if not its semantics, the speech still reflected the careful logic of an experienced attorney. Mark Neely, here this evening, has likened it to a history lecture more than a stump speech. And John Frank has praised it as, quote, a superb combination of political argument and legal brief, end quote. For our purposes, it nicely illustrates how Lincoln, in the year of his election as president, had effectively integrated his courtroom skills with the dictates of effective public oratory. Turning to a more difficult task, we now explore the Lincoln mind that uttered those words and decided vital issues. Both a good lawyer and a good Whig, as George Frederickson has argued, both a good lawyer and a good Whig, as Lincoln, as George Frederickson has argued, believed that social order, individual self-restraint, lawfulness, constitutionalism, and reason, cold, calculating, unimpassioned reason, were society's bulwarks against disorder and vigilantism. He thus drew intellectual inspiration and political arguments as well as an income from his law practice. My favorite source on this subject is Philip Shaw Paladin's acclaimed book, The Presidency of Abraham Lincoln, from which I shall draw generously. Paladin argues that Lincoln, quote, believed in the political and legal institutions of his age because he was a successful product of them. He therefore, if reluctantly, accepted slavery's legal standing and even that of the fugitive slave laws. A sharp critic of the tawny Supreme Court's Dred Scott decision, he nevertheless acknowledged its lawfulness, challenging only its wider application as precedent. None of Lincoln's presidential messages better illustrates this dedication than the first inaugural. Paladin and others have characterized its central argument as a well-constructed legal brief. A career spent on Lincoln's part on the mutual obligations inherent in contract law prompted Lincoln to frame the secession crisis accordingly. Challenging the lawfulness of the Southern renegades, he declared that, quote, one party to a contract may violate it, break it, so to speak, but does it not require all parties to lawfully rescind it, end quote. After Fort Sumter, the president felt compelled to exercise emergency powers before Congress could assemble in special session. He called up state militias, announced the blockade, and suspended the writ of habeas corpus in selected areas, later asking Congress to ratify his actions. While exercising authority to the limit, and in a few cases beyond the limit, he nevertheless took pains to defend these actions in both practical and legal terms. In searching for the lawyer in Lincoln's presidential behavior, one is correct to emphasize core beliefs over routine incidents. John Frank saw an experienced lawyer's mind in the positions that Lincoln took on the Dred Scott decision, secession, emancipation, the theory of wartime necessity, and the delegation of executive authority. To him, emancipation was much more a political dilemma than a legal one. Lincoln had no doubt about his right as commander-in-chief to confiscate property, that is, slaves, in the contested areas. But he sought less extreme alternatives and delayed acting for political and practical, not legal reasons. When finally issued in January of 1863, the Emancipation Proclamation was anything but an eloquent statement of human rights. Rather, as Neely has written, it was couched in leaden legalese. Others have likened the prose to a bill of lading, or, quote, an ordinary summons sent by one lawyer to another, end quote. Paladin argues that, quote, the language had to be a lawyer's language because Lincoln was taking legal action, end quote. While uninspiring and stilted in its legal rhetoric, the proclamation still had revolutionary implications. One minor but revealing example of the prairie lawyer's mind at work in the White House was his response in 1864 to a clemency petition seeking Josiah Grindal's release from custody while he languished in prison awaiting trial on federal charges of treason stemming from the Baltimore secessionist riots of April 1861. Because Grindal had been confined for 3 years, he did not qualify for automatic release under the president's recent proclamation of amnesty. After reading the court documents and the defense lawyer's plea for clemency, President Lincoln neatly wrote along the paper's margin, quote, in this case, not as a precedent for any other case, the district attorney will be justified by me if in his discretion he shall enter a nolle prosequi, that is to say, a motion to drop charges. This notation by Lincoln reflects the lingering lawyer in President Lincoln in several ways. It is semantically crisp, it is narrow in its application, and it is deferential to the U.S. Attorney's superior knowledge of the defendant and the circumstances. Lincoln brought the same legal perspective to other wartime issues. Time does not permit a detailed analysis, but one can readily detect a lawyer's mind and a lawyer's method in his reversal of General John Freeman's emancipation order in Missouri, his opinion to Congress regarding the admission of West Virginia as a state, his pocket veto of the Wade Davis bill, his careful management of Reconstruction in Louisiana, and his insistence on conducting the 1864 presidential election despite wartime exigencies. Therefore, Abraham Lincoln's writing, speaking, and thinking in the public arena owed much to his legal career. With no prior experience as an executive, as party leader, or as commander, Abraham Lincoln brought to his heavy White House burdens the one body of experience, law, that had served him well for a quarter century. Thank you.
Thank you very much, Colin. These presentations this evening are sequential. Colin Davis has given us an overview of Lincoln's legal background and has hinted at its relationship to his performance as president. Now, our next speaker will take a closer look at Lincoln as lawyer from the standpoint of one who might parse his legal writings as if she was editing them for publication, which is only right, because that is exactly what she does. Stacy Pratt Mcdermott is assistant editor of the Lincoln Legal Papers in Springfield, Missouri. I'm sorry, Springfield, Illinois. Springfield, Illinois is the capital of Illinois. It is not in Missouri. Although much can be said this evening about Missouri, because there is where some of the most stringent acts in the form of military commissions and suspension of habeas corpus took place. But that's for our next speaker, Professor Neely. Stacy Mcdermott holds a master's in history from the University of Illinois, Springfield, Illinois. And she is currently a doctoral candidate at the University of Illinois at Urbana-Champaign. She is the author of a number of scholarly articles on law practice, substantive law, and procedure in antebellum America, and is a preeminent authority on Lincoln's own law practice. Her topic is Lincoln's approach to the law. Stacy McDermott.
In February 2000, the Lincoln Legal Papers published The Law Practice of Abraham Lincoln, Complete Documentary Edition. This is a 3-DVD ROM set. The edition represents a 14-year collaborative effort of more than 40 people, and it documents Lincoln's 24-year career at the bar. The edition features information from more than 5,600 cases and non-litigation matters that Lincoln and his 3 law partners handled from 1836 to 1861, and it includes images of more than 96,000 documents. The reference section of the edition includes images of 1839 and 1856 Illinois statutes, biographies of lawyers and litigants, and a glossary of legal terms, a chronology, and essays on Lincoln the lawyer, and antebellum pleading and practice, and court structure. My prepared remarks tonight are based on the resources available in this documentary edition. It is a wonderful resource for scholars of Lincoln and antebellum law, but also for teachers and for students. I would encourage you all to explore the edition. It's available here at the New York Public Library and at various law libraries in the metropolitan area. That's my little plug. My basic task this evening is to contextualize the 3 documents included in the keepsake packets you received, and hopefully, in the process, offer some insights about Lincoln's caseload specifically and antebellum law more generally. First, I want to talk about Lincoln the lawyer and share with you how I characterize Lincoln's approach to the law. Abraham Lincoln had a successful law practice with a varied caseload, personally handling more than 3,800 cases and non-litigation matters in the course of his career at the bar, and Lincoln distinguished himself as a capable, versatile attorney. While debt represented the largest percentage of the cases he handled, Lincoln was an accomplished litigator whose caseload included such diverse issues as divorce, railroad finance, real estate transactions, and inheritance. As an advocate for plaintiffs, Lincoln foreclosed on mortgages, sued for compliance of contracts, handled slander cases, and filed injunctions. As a defense attorney, he represented debtors, thieves, incompetent office holders, violent offenders of the public peace, and slaveholders. Lincoln was a hard-working general practice attorney who handled cases as they came to him. Lincoln scholars often characterize Lincoln as compassionate, possessing a capacity for empathy and kindness, and they frequently apply those personal characteristics to his approach to the practice of law. While it is hard to ignore those countless stories that support Lincoln's good moral character, an analysis of his law practice reveals that Lincoln rarely inserted his personal morality into the cases he handled. When one looks at the entire corpus of his cases, it becomes obvious that Lincoln did not cherry-pick cases that were in line with his personal moral beliefs. Nor is there substantial evidence to suggest that he frequently refused cases that may have been out of line with his own principles. Had he limited his practice to cases in which he personally agreed with the client's claims, one could argue that he would have had a pretty difficult time making a living. Lincoln took cases to earn a living, but an analysis of his practice also reveals his developing belief in a code of ethics that regulated the relationship between attorneys and their clients. In 1834, an Illinois Supreme Court opinion discussed issues regarding attorney responsibilities. And Justice Sidney Breese wrote the opinion, and he wrote, quote, "To the lawyer is confided the cause of his client, and the issue of that cause may be involved property, life, liberty, and character. It results then from the magnitude of the interest committed to him that he may be the means of much good or extensive mischief," end quote. The case for which Breese crafted this opinion upheld a civil case, in which a client had successfully sued his attorney for damages caused by the attorney's misrepresentation of the client. Rather deliberate misrepresentation, it turns out. The professionalization of the practice of law coincided with this developing professional code of ethics, and it was evident on the antebellum frontier where Lincoln practiced. If an attorney violated his oath and his responsibility to his client, he jeopardized his license to practice and therefore his livelihood. Where his clients were concerned, Lincoln was interested in doing good, not mischief. When Lincoln accepted a case, regardless of the moral righteousness or lack thereof of the client or the cause, Lincoln was a determined advocate. He represented his clients to the utmost of his legal abilities, and he did not evade his attorney's responsibilities to his client. Lincoln took this responsibility seriously, and although there are a couple of incidents in which he counseled those he represented to go easy on the opposing litigant, he never deliberately faltered in representing the paying client. Within the body of Lincoln's cases, there is much evidence of Lincoln, the lawyer's, amoral approach to the law. Lincoln structured his legal approach based on the specifics of the case at hand, and he crafted his arguments from the facts that he believed would best advance his client's case and not necessarily on his own personal judgments on the issues. Within Lincoln's law practice, there are numerous examples of Lincoln representing opposing arguments in the same issue. In the 1847 Habeas Corpus case of N. Ray Bryant et al., Lincoln represented Robert Matson, a slaveholder, and argued against the freedom of the petitioning Jane Bryant and her 4 children. In the case, Lincoln used the doctrine of comity to argue that slave owners could use their slaves for labor in Illinois as long as the slaves were in transit through the state. The court rejected Lincoln's argument and declared Bryant and her children free. 10 years later, Lincoln would vehemently object to the Dred Scott decision, which the U.S. Supreme Court had based on the doctrine of comity, the very argument that Lincoln had used in the Matson case. In another pair of cases, Lincoln argued in support of water transportation interests in one and railroad transportation interests in another. In 1854, in the Columbus Insurance Company versus Peoria Bridge Company, Lincoln, representing the insurance company, argued that the bridge company had no right to obstruct a navigable stream. In 1857, in Hurd et al. Versus the Rock Island Bridge Company, Lincoln, this time representing the bridge company, argued that the railroad bridge had a right to unfettered crossing of the Mississippi River. Had either the Peoria Bridge Company in the first case or Hurd in the second case retained Lincoln's legal services, Lincoln would have most assuredly argued the opposite position in both cases. The letters included in your packets tonight provide some clues about Lincoln's approach to the law and to his clients. And they shed some light on the nature of Lincoln's practice and offer insights about the sometimes routine matters that occupied Lincoln for much of his professional life. Chronologically, the first document is a Lincoln letter to James Irwin. In November 1842, when Lincoln wrote to Irwin, an attorney from Brown County, Illinois, Irwin had concluded a debt case in which he had won a $584.92 judgment for his client, Henry Cheseldine, against Greenleaf Robinson and Thomas Adams. The defendants in the case had failed to pay the judgment, and the local sheriff, Irwin, levied 130 acres of Robinson land to sell at public auction to satisfy the judgment. When the sheriff failed to appraise the land according to an act of the Illinois General Assembly, which regulated the sale of property, Robinson sued for an injunction to restrain Cheseldine and the sheriff from selling his land. The court dismissed the injunction, and Robinson appealed to the Illinois Supreme Court. When litigants filed appeals to the Illinois Supreme Court, it was very common for them to retain the legal services of another attorney, either one who had more appellate experience than their circuit court attorneys, or who resided in Springfield, Ottawa, or Mount Vernon, the towns in which the state's highest court met. Oftentimes, attorneys in rural areas located a long distance from the Supreme Court worked with appellate attorneys in those locations to handle the appeals of their local clients. Lincoln received and accepted numerous requests for such appellate work. He was a very popular attorney for other attorneys to turn to in these matters. During his legal career, he handled more than 150 appeals for clients who had employed local attorneys to handle their cases at the local level. Through Irwin, Cheseldine and Nye retained Lincoln to handle the appeal of their case. Lincoln wrote James Irwin that he was willing to take the case on appeal. He was hesitant to set his fees in the case, but assured Irwin that they would be reasonable. This letter reveals Lincoln's tendency to set his fees on a case-by-case basis. It also reveals his readiness to ask clients who lived far away to pay in advance of any legal work he might conduct. Although there is evidence that Lincoln occasionally waived fees for particular clients, Lincoln practiced law to earn a living, and he was not shy about collecting fees for his services. Robinson v. Cheseldine and Nye came before the Illinois Supreme Court in December 1843. At issue was a jurisdictional question, a rather boring one, I'm afraid, of whether or not Robinson could pursue the injunction in Chancery Division of the court before he had exhausted common law remedies for debt. The Supreme Court ruled that Robinson should have pursued the common law remedies, declared that the Chancery Court had no jurisdiction, and affirmed the judgment of the lower court. With the decision, Lincoln successfully defended Cheseldine and Nye and ensured that James Irwin's client back in Brown County could collect his nearly $600 judgment. The second letter, Lincoln to Lewis Hayes, represents an example of the kind of evidence on which Lincoln scholars and enthusiasts like to focus to depict Lincoln's particular qualities of empathy and kindness. Lincoln advised Hayes, his client in a simple debt case, that he was really sorry for the defendant, George Turley, because he was poor and crippled. Turley had given Thomas Taylor a promissory note for $100. Turley failed to pay before Taylor's death in 1837. Hayes, the administrator of Taylor's estate, retained Lincoln and sued Turley to collect the debt. In the letter to Hayes, Lincoln wrote that he had given Turley extra time to find evidence to support his claim, that he had offered payment to Taylor, but that Taylor, on his deathbed, had promised to forgive Turley's debt. The case was continued while Turley produced his witnesses, which he did in the fall of 1853. Lincoln's sympathy for the opposing client in this case cost his client interest on the debt because the court ruled that Turley should pay only $100 as interest could not be allowed between the offer to pay in 1837 and the bringing of the suit in 1851. The interest could have totaled more than $100, as 12% annual interest was typical at this time in cases like this. It is very likely that Lincoln could have pushed for a judgment early on in the case and gotten those extra charges for the client. There is no way to deny the fact that in this particular circumstance, Lincoln did show empathy for the opposing litigant. However, it is critically important to note that the surviving documentary evidence reveals that this was most likely an isolated incident. And in the end, Turley was held responsible for the original debt, even though he appears to have proven that the decedent had forgiven him. So Lincoln didn't go that easily on him. The third letter in your packet demonstrates Lincoln's legal work for out-of-state litigants. The issue that Lincoln discusses in the letter involved a debt over a mill in the state of Ohio. James Kelly had recovered a judgment against Jesse Blackledge. Blackledge failed to satisfy the judgment and moved to Illinois. This was a common problem for Lincoln and his contemporaries, trying to find where these people were. People were moving around quite a bit. Kelly, through his attorney in Ohio, Anson Brewer, retained Lincoln and sued Blackledge to recover the debt. Blackledge died, Kelly dismissed the case, and Lincoln filed a claim in the Logan County Court against David G. Edmonds, who it appears as though maybe Lincoln didn't like too much. A problem with Kelly's documentation of the debt delayed the claim. Therefore, because Lincoln failed to file the claim within the time the statute required, the court refused it. Kelly appealed the judgment to the circuit court, which ruled in favor of his claim by awarding the original judgment in the Ohio case. In the letter, Lincoln exhibited his frustration with the county judge's decision in the case. The letter also reveals the rudimentary proceedings of law and the ways in which Lincoln's cases required him to understand the various details related not only to the minutiae of filing deadlines in a variety of courts, but also of the various jurisdictional differences between legal process and judicial personalities. This letter is typical of many of the letters that the Lincoln legal papers uncovered over the years that reveal Lincoln's diligence in keeping his clients, especially those out of state, informed about their legal matters. There is much evidence to show the level of respect that Lincoln extended to the people who relied on him to solve their simple as well as complex legal problems. So, as a group, what do these letters reveal about Lincoln's law practice and his approach to the law? First, the letters demonstrate the importance of Lincoln's attention to detail and his talent for handling diverse legal issues in multiple jurisdictions with people of varying personalities and dispositions. Sounds a little bit like the problems he might have had with his cabinet and the presidency. Much of Lincoln's caseload involved routine, pre-pleading, and practice. But to his individual clients, those everyday, mundane legal matters often represented significant legal, economic, and social consequences. Lincoln understood that, and attorneys and litigants alike recognized that quality in Lincoln and sought out his legal services. Second, the letters reveal Lincoln's ability as a communicator and show the way in which he interacted with clients. Once retained, Lincoln was a powerful advocate, and he treated his clients with respect and handled their legal problems much as if they had been his own. I believe that Lincoln thrived on the personal interaction with clients, lawyers, and officers of the court, even the ones he didn't like so well, that his flourishing law practice demanded. And throughout his travels on the circuit and in his federal and appellate practice, Lincoln garnered much of his political support from the lasting, positive impressions he made on many of the hundreds of ordinary and not so ordinary people with whom his law practice brought him into contact.
Well, This takes us to our third speaker. And following him, there will be a panel discussion in which all three of our speakers will address the questions that have been posed at the beginning of this program. The issue now, though, I would say, is how do these characteristics of Lincoln as lawyer figure in explaining, or how do they relate to the actual conduct of Lincoln as president with respect to these issues of personal liberty and internal security. Our next speaker is, without a doubt, the foremost expert on the question of Lincoln and civil liberties during the Civil War. Mark E. Neely, Jr. is McCabe Greer Professor of the History of the Civil War at Pennsylvania State University. For 20 years, he was director of the Lincoln Museum in Fort Wayne, Indiana. He's author of a number of books, such as The Union Divided, Party Conflict in the Civil War North, a biography of Lincoln, The Last Best Hope of Earth, and, of course, his Pulitzer Prize-winning book, The Fate of Liberty, Abraham Lincoln and Civil Liberties, a 1992 publication of the Oxford University Press. Professor Neely is currently working on a political history of the Civil War, but you in this audience have had an opportunity to see the first edition of his most recent writing, his introduction to the keepsake, which is handed out this evening, and for which we have most deep appreciation because he prepared that under remarkably short time constraints. And we thank you very much for that, Professor Neely. Mark Neely's topic tonight is civil rights during the Civil War. What really was Lincoln's record? Professor Mark Neely.